And welcome to the Legal Lounge here on CRN Digital Talk Radio, CRNTalk.com, coast to coast around the world, streaming live on CRNTalk.com, also on Facebook.com/CRN Talk, Tiki Live, Roku, and anywhere you can find us. I'm joined, as always, by the one and the only active attorney, U.S. Army veteran, Juris Doctorate in Law, undergraduate degree in physics, and author of a book that has proven to be a guideline for the Supreme Court now and in the future. That book, America, An Illusion of Freedom, is available on Amazon.com, Barnes & Noble, and on iTunes. Ladies and gentlemen, Mr. Richard Nixon in the show that gives you the news you get nowhere else. How are you, Richard?
I'm pretty good. I was kind of down for a while because I kept watching television. Everybody was saying that Miss Kamala was neck and neck with Mr. Trump, and she could even win the presidency. And I'm going, what? Based on what? But I feel a little better now that I've seen her in action in that so-called interview that she was there, including her named vice president,
Mr. Walls.
Yes, why she would need a man to help her, that kind of says something. And I can't imagine the people that set that up, because if you look at the way it was set up, she looks like a little girl sitting in the chair between these two big adults. I think it was so poorly done, and I think she wasn't really prepared. Her answers were all cliches or hackneyed phrases and so on. So I don't think I'm too worried anymore. And I think if we can get Trump to debate her, and I don't think the problem is with him, it's with her, I think he's going to expose her as being an empty suit, if you will.
Yeah, I mean, even most of the media leading up to this, and of course, most of the media out there, mainstream media, that is definitely not Team Trump. They were screaming for her to sit down for an interview because I guess it was over 6 weeks since she was installed as the Democratic nominee, where she was actually had to sit down and answer some questions. Donna Bosch, I thought, did an okay job, but like you said, it seemed that, and you're right, the way that the camera was, it was kind of profiled, where Tim was in the foreground, Tim Walz was in the foreground, and then we have Kamala kind of off to his side.
Walz the Walrus.
So we're going to be definitely looking at that. We got a big show today. We're going to talk a little bit of all the things in the news regarding legal issues and constitutional issues. Right after this break, we're going to talk about the downfall of Tom Girardi, who's been found guilty of all counts, wire fraud, mail fraud, any kind of fraud, defrauding people.
That's too bad.
Left and right. I mean, he was a legal legend here, in, not only nationwide, but especially here in California, Los Angeles, where was the area of his practice. We're going to talk about, Richard and I are going to take a victory lap over an interesting development in the Jack Smith January 6th case. We're also going to talk about an interesting case out here in the state of California regarding involuntary commitment, and check in with a couple Second Amendment cases as well, because as we know, we're living in a post-Brune world. So once again, thank you so much for joining us here in the Legal Lounge. As always, all past and previous sessions, this high-quality broadcast are available on Rumble and also on YouTube. Find CRN Digital Talk on both those platforms, as well as a podcast at crntalk.com/podcaster. And as always, make sure to check out Richard's fantastic book, America, An Illusion of Freedom. It's available on Amazon.com, Barnes & Noble, and on iTunes. Stay with us.
Hi, everyone. If you've been injured in an accident that was not your fault, listen up. We have legal professionals standing by to answer your questions for free. Call now and find out if you have a case and how much it's potentially worth. Call 800-745-9090. I'm here with spokesman John Wolf. So, John, tell everyone listening who should call right now.
Well, Maria, first off, thank you for having me here. It's always nice to answer the listeners' questions. Now, as far as who should call in, anyone who's been injured in an accident and think you deserve compensation, give us a call right now. 800-745-9090. You'll find out if you have a case and how much it's potentially worth.
Thanks, John. You heard it, folks. Take advantage of this opportunity and call now. 800-745-9090.
Advertisement sponsored by Legal Help Center, may not be available in all states.
back in the Legal Lounge. Once again, thank you so much for joining us here. We really appreciate it. And Richard, let's talk about the aforementioned Tom Girardi, a famous litigator, first guy in California to ever win $1 million medical malpractice suit. Got $640 million judgment out of PG&E for the quote-unquote Aaron Brockovich case, and $4.6 billion with the B, folks, in the Vioxx case. But Richard, he's fallen on hard times.
Yeah, it's too bad. And I remember I tuned in several times, and I used to see the Daily Journal ad for his show on AM 870 and 790 ABC radio show touting his program called Champions of Justice. And now when you look back, it's kind of ironic that that's what really happened. Anyway, just recently here now, a federal jury found disbarred plaintiff's attorney Tom Girardi guilty of 4 counts of wire fraud Tuesday after a 3-week trial for pilfering $15 million from 4 clients who had been severely injured or lost family members in accidents. Girardi, 85, whose attorneys told the jury he has dementia and Alzheimer's disease, was not taken into custody. Sentencing was set for December 6th. His conviction under U.S. Code 1343 carry a maximum sentence of 20 years in federal prison and large fines for each count. It goes on to say briefly, Mike, this verdict represents a remarkable fall from grace for Mr. Girardi. U.S. Attorney Martin Estrada told a news conference outside the courthouse. Mr. Girardi took advantage of his clients when they were most in need. Mr. Girardi portrayed himself as a champion for the little guy, but Mr. Girardi was no champion of justice. In fact, he was a perpetrator of injustice.
Yeah, a sad state of affairs here. Of course, Mr. Girardi, very famous. Also, some of these charges include he stole $3 million in settlement funds intended to families of the 189 people killed in a 2018 Boeing airline crash in Indonesia. And we talk about this a lot, Richard. You really got to be on your P's and Q's when it comes to that client trust account.
Yes, and it's so easy to do, as we talked about in our show prep. The attorney, it's called a trust account because the law entrusts the attorneys to have funds that eventually belong to their client, and to, at least in a PI case, to the doctors or hospitals or nurses, whatever. So you end up with a pile of cash. It's in the attorney-client trust account. It's in control of the client, of the attorney. He's got his checkbook there. And it's so tempting to simply either not pay his client or not pay the doctors or the hospital, and to actually kind of just pay himself and go out and buy himself a new Mercedes or whatever he thinks he needs. And of course, if he's supporting a beautiful younger woman, that doesn't help either.
Yeah, famously, Mr. Girardi married a singer named Erica, an actress and singer and influencer named Erica Jane, who is 32 years his junior.
Oh,
and of course, she was also a cast member on the Real Housewives of Beverly Hills. And so, he was in not only the public eye for his lawyering, but also because of his very cute wife. But Richard, you said during our prep session is that with the client trust account, 2 things here is that a lot of solo practitioners, especially if they run into cash flow issues, that sometimes they're like, oh, well, I know I got this money coming next month, and so I'm going to take the money out of the client trust account this month to pay down some of the bills. But also what you said, too, is really interesting is that, good practice is to, when you have funds in the client trust account, get them out as soon as possible, right?
Well, that's right. And the estate bar will tell you that it's pretty much earmarked. Well, let's assume you settle a personal injury case for $90,000. You pretty much know, based upon the papers that you've signed before this case was settled, that you, the attorney, are entitled to $30,000, the doctor $30,000, and the client $30,000. Now, once that is established, there's no reason why you can't immediately disperse those funds to each party. Take 30 for yourself, et cetera, et cetera. However, what happens, and what can happen with attorneys, is they stall, and when the attorney, the client says, hey, wait a minute, didn't we settle this case? No, it's not quite settled yet. The insurance companies giving us, a rough time. Anyway, oftentimes what attorneys will do actually to help the client is to kind of dick around, debate with the doctor. Instead of paying the doctor $30,000 off the bat, he might say, "Doc, look, how much would you take to settle this thing right now?" And oftentimes the doctor will say, "We'll take 15." Okay, so he sends the doctor 15, and he sends him a letter to sign that it's a full settlement. Now he's got an extra 15. Now, if he's scrupulous, he will give that extra 15 to his client who was heretofore entitled to 30. Now he gets 45. However, if he's unscrupulous, he gives the client 30 and he keeps the 45. And I'm afraid that's kind of what Mr. Girardi, similar to that, was doing. I can't say for sure. I don't know the facts of the case. But that's a typical scenario for how attorneys get in trouble, because eventually somebody squawks.
And you mentioned too, and this is fascinating information that I don't think a lot of the public realizes for non-attorneys, is that you set up your client trust account. Let's use Bank of America for example, because I bank there. And if the state bar isn't like looking into your client trust account, but sometimes the bank might notice something not necessarily above board going on there, and they will contact the bar.
That's right, because a lot of times what happens is that the attorney-client trust account has a shortage because the attorney has paid everything out like he's supposed to do, but now he's in the red because the bank charged him interest that he cannot pay now. And so what he might do in his next case is use part of maybe his client's money to pay that interest. Now, what he should do, of course, is pay it out of his own share, and then there would be no problem. However, that leaves him with less money. I don't think that's anything Mr. Girardi was would consider doing.
Yeah, because I mean, the man has won nearly $5 billion in settlements.
It's amazing, isn't it?
And so if he, even if he was part of the team, I mean, he's probably had some cash lying around. So his defense, of course, was that he was suffering from dementia and that his underlings in his firm were the real ones doing this, taking the money of $15 million between those 4 client accounts between 2010 and 2020. Of course, he's been disbarred. Do you think he's going to serve jail time at this, first-time offender, advanced age?
It's so hard to say because he's 85, and he doesn't look good.
No.
From what I've seen, he's got this really big belly. He's obviously, I think he's not healthy. Who knows what they'll do? In fact, maybe they'll give him some kind of home arrest or probation. The real issue here, though, that the clients want is the money.
Yeah, give them the money back. Yeah.
Somehow figure out a way of paying them back. I don't think they really need to. These people were in many cases his friends, if you will. Yeah. And that's how he got these cases. So I think they're more concerned if they can find to get some money from him. I think they'd be happy.
I think so too. I think if they can recoup, I think that he doesn't. There's no deterrent here. I mean, he's an old man, and I don't think necessarily jail time is warranted here. Stick around, you guys. We'll be right back right after the break. Stay with us.
The Kaanapali Beach Resort Association is reopening and is welcoming guests. While some properties are opening sooner than others, all properties are taking reservations, and we look forward to your return. Go to kaanapaliresort.com for all the latest and up-to-date information on what's happening at Kaanapali Beach. That's Kaanapali Beach on the west side of Maui. There's so much to do. With a short drive from Maui Airport, we're on the tropical side of Maui and offer breathtaking scenery, an incredible array of delectable dining, and activity choices to meet your needs. We invite you to visit Kaanapali Beach Resort, but please be sensitive to the devastation that our beloved West Side community has suffered. Lahaina is closed and will be for some time. Come to our open areas and support us as we adapt to a new way of life without our beloved Lahaina. Come visit the west side of Maui, Kaanapali Beach. Visit us online at kaanapaliresort.com. That's Kaanapali resort.com.
If Ernest Hemingway was alive today, would he say this to you?
Shakespeare, Mark Twain, Edgar Allan Poe, all great writers. And after reading your book, I simply must add you to the list.
Wait, you don't have a book yet, so make a free call to Page Publishing. Their expert staff can help you turn your book idea into a real book, a masterpiece that could someday make the bestseller list in hard copy and digitally all across the world. Page Publishing can help you completely take your idea for a book, write it, and publish it. So if you want to join the ranks of some of the most famous authors in the world, call now for a free information kit. Turn your book idea into publishing gold. Make a free call right now to Page Publishing.
800-378-3212. 800-378-3212. 800-378-3212. That's 800-378-3212.
You see it and you feel it. Spending and inflation are on the rise. The dollar is falling. Why are we borrowing and paying interest on our own money? Why haven't we eliminated the Fed? It's time to get real and bring back sound money. Don't be left behind when this economic bubble breaks. Protect your nest egg with physical gold and silver from Midas Gold Group. When the chaos of big government and big banks fail you, save your financial freedom and future with a call to veteran-owned Midas Gold Group, 855-322-4653, 855-322-GOLD, or always at MidasGoldGroup.com. Don't wait for trouble. Protect yourself now with Midas Gold Group, 855-322-4653. That's 855-322-GOLD. MidasGoldGroup.com. It's gold you can hold.
And we are back in the Legal Lounge. Once again, thank you so much for joining us. And in Richard's fantastic book, American Illusion of Freedom, he writes extensively about the United States Constitution. And we talk about the Constitution a lot on this show. Talked about the First Amendment a lot, the Second Amendment a lot. The Third Amendment, not too much, Richard.
No.
The Fourth Amendment we talk about a lot. The Fifth Amendment we talk about a lot. And the Sixth Amendment, I can't remember a case where we talked about the Sixth Amendment. And what is the Sixth Amendment, Richard?
Well, it's the Miranda case, basically. It's the idea that you have a right to counsel and that you can call witnesses against yourself and so on. So it's kind of a conglomeration of different protections, if you will. Mm-hmm. So, but anyway, in this particular case, let me read the facts very quickly. Petitioner Victor Raul Tellez was charged with 3 counts of violating Penal Code Section 288 for lewd or lascivious act upon a child and faced a maximum prison term of 12 years. As part of a plea deal and on the advice of his attorney, Tellez pleaded guilty to a single felony violation of this Section 288 and was sentenced to 3 years in prison. So he got 3 instead of 12. Now, Tellez was not told by the court, underline the word court, in entering his guilty plea that the conviction would make him eligible for commitment as a sexually violent predator. After Tellez completed his 3-year prison term, the DA of the County of San Diego initiated the SVPA proceedings for Tellez's involuntary commitment to a state hospital. Now, he's still there. And he's arguing that I had ineffective attorney. I have a Sixth Amendment right to a good attorney, if you will. And I was given improper or inadequate attorneys because the form that I was told to sign and to initial actually had a box there that said, now remember, if what you're pleading to here, if it has anything to do with the SVPA, that is a sexually violent predator, you can, after you serve your time, actually be transferred to civil commitment. Now, that box was not checked. Now, his attorney should have been watching him to make sure that he did check that box. So I think he had a good argument here. And it was 7-zip on the California Supreme Court against him. However,
big however coming here.
yeah, but however, Justice Liu said just what I said. No. There's a violation of the Sixth Amendment here, too, because either he or the court should have told him that, you might end up in a mental institution, which is the case. I think he's now on his 7th year, if I'm not mistaken. And there's no definite time limit.
Yeah.
The worst part about it, and let me get this out, Mike, is this. All this fighting that he's doing, it's strictly prospective, does not apply to him.
Yeah.
It only applies to people after him.
That's my however. Yeah, that was my big however.
And what it says too, though, is they didn't make the attorney liable for any malfeasance. What they were saying is the court from now on is advised to give that kind of proviso to any defendant that happens to be in this particular situation, where he might end up serving some time as a civil commitment.
Yeah, the court took some of the logic and case law from a Supreme Court decision in Padilla versus Kentucky, where defense attorneys must advise non-citizens their risk of deportation if they agree to a plea deal. But yeah, the defendant here, he seems, Mr. Tellez seems, creepy, but. Yes, the court did rule that judges must warn violent sex crime defendants of civil commitments, but yet it is not retroactive. And so the defendant here, Mr. Tellez, is not entitled to any relief.
It seems to me, I know why they did it, because they didn't want a rush to the courthouse for all these guys saying, hey, I want out. I wasn't given the proper warning either. However, you could limit it right there. You could say that this case applies to, this ruling applies to this case only, period.
Yeah, that's pretty common. That happens, especially at the appellate level.
Of course it is.
Yeah.
Now, I don't see the problem here. And in fact, I don't understand why the other 6 didn't agree with Lou, because I've done these before. You sit in a hallway with the client, and there's a bunch of boxes he has to check, and you make sure he understands everything he's reading there. And the one that applied to him, he did not check. Now, if that isn't malpractice, I don't know what is.
Yeah, and I would be quite angry if I was this defendant. But interesting case, Richard. Thank you for bringing this to our attention. And we'll be right back right after the break, because Richard and I have to take a victory lap on another successful prediction. So stick around for that, you guys. Stay with us.
No more mold, no more damage, no more outdated old bathroom, no more slipping and hurting, no more stress. Make your ordinary bathroom extraordinary for only $99 per month. New shower, new door, new tub, new wall, new anti-slip technology. Be stress-free. Call 800-973-5411. BCI Bath and Shower is made in America for the highest quality. Ask about our military and senior discounts. Your dream bathroom in as little as 1 day. First 50 callers save $1,500 on a Never-Clear glass treated door. Call now for free premium color upgrades. 800-973-5411. Call BCI Bath and Shower, the leader in bathroom remodeling. Be smart, safe, and stay a step ahead of inflation with our interest-free financing options. Call 800-973-5411. Love your bathroom with free upgrades. Call 800-973-5411. 800-973-5411.
Attention real estate investors. Do you need cash immediately? If you own one or multiple rental properties, you can use your equity to get cash out fast. The best part is we don't need tax returns or even a good credit score. At America's Loan Source, we are not a bank and we don't have bank rules. We make the decisions to loan you money, and there's no limit how much we can give you. Some clients have gotten as much as $500,000 or more within days. Use the money any way you want. If you own one rental property or 100, and COVID has left you in a cash crunch, we can help you turn your equity into fast cash. Call now for details and close in as little as 10 days and get the cash you need. 800-353-1760. 800-353-1760. 800-353-1760. That's 800-353-1760.
You order a glass of your favorite Cabernet, fresh asparagus, hollandaise on the side, a filet, medium rare. You unfurl your napkin with a flair, close your eyes, and prepare to listen. Ah, there it is. The sweet music you long to hear. The sizzle. The sizzle of a Ruth's Chris steak.
The most magnificent corn-fed prime beef, broiled to perfection at 1800 degrees. Some call it a sizzle. We call it an anthem.
As the waiter approaches, you think, is this one mine or that one?
Ruth's Chris Steakhouse. Like Ruth always said, life's too short to eat anywhere else.
Make a reservation online at ruthschris.com or by calling 800-544-0808.
Hi everyone, Fred Dreyer here with a special trial offer for Steelman pills. These pills have been proven to help men improve their performance. Order your Steelman pills right now and get an additional 4 pills free. That's a retail value of $200 and we're giving them to you free. That's right, with your $99 trial order. Call us right now and claim your Steelman Blue Pills for just $99. Call 800-847-1077. That's 800-847-1077. This offer is exclusive to our radio listeners from Steelman Pills. Order our male enhancement Steelman Pills and get 4 additional pills free. Call now 800-847-1077. 847-1077, 800-847-1077.
And we are back in the Legal Lounge. Once again, thank you so much for spending some time with us. All past and previous sessions are available on YouTube, also on Rumble. Find CRN Digital Talk on both those platforms. Also, you can watch us live or after the fact on Facebook, facebook.com/CRN Talk. All right, Richard, I think we're ready to take our victory lap here.
Well, yes and
yes
no.
and no.
You are entitled to almost 100% in the victory column because you called it that the Supreme Court, when it did issue this January 6th case on immunity, that they would somehow split the baby and give him immunity for certain things but not for others. And I kind of said, well, yeah, you're probably right on that, Mike, but I predicted, if you will, that if they did that, it would simply encourage whatever was left over there as unofficial, if you will, because the split was going to be between immunity for official acts and not immunity for unofficial acts. I said all it's going to do is shift the case back down to the trial court. The trial court is going to find some acts that Trump did that they can claim are not official, and bingo, there we go. We've got 4 more, and that's exactly what Jack Smith did. Just very briefly, what the Supreme Court did on Monday, several Mondays ago actually, said that former presidents can never be prosecuted for actions relating to the core powers of their office, and that there is at least a presumption that they have immunity for their official acts more broadly, and again, no motives, so it was remanded. Now, it went on to say, the case now returns to the lower courts for them to determine whether the conduct at the center of the charges against Trump was official or non-official. So where are they sending it? back to Jack Smith.
So how does that work, though? So are what acts that are official or unofficial, is that determined during the trial phase? Do they present this to the jury and the jury decides, or is this like a motion thing where a judge would decide what's an official act and what's an unofficial act?
Well, yeah, it's going to be strictly up to the judge as to how he wants to determine it. If he thinks it's a question of fact, he might just call the jury to determine it.
So long-suffering Judge Tanya Chutkin's going to have to the one to field all these motions. So, I mean, brass tacks here is this is going to play out in years, not in months, right?
Well, yeah. And you see, you got to remember now, all that's happened in this January 6th case is they filed complaints. Means nothing. I mean, those complaints might be bogus, but it's something that Trump has to now address. And, of course, they're saying by the time he answers, and they maybe have some motions, and they argue that Jack Smith should not even be, he is not qualified to pursue this case in any event. They should go like the Mar-a-Lago case went and find that he's not capable here or he's not qualified. But all they've done is muddy the water, but that's exactly what I predicted, because I said, if you give him anything less than total immunity, they'll follow him for the next 4 years, assuming he gets elected. And every time he turns around, they're going to be noting this and noting that. When he gets out, assuming he wins, they'll hit him again with these bogus claims. At least I claim so. And I'm claiming that it's very simple. The way we are supposed to do this is through the, let me get it here. The so-called Article 1, Section 3, Clause 7 of the Constitution says, the judgment in cases of impeachment shall not extend further than to removal from office, but the party convicted, in this case it would be Donald Trump if he were ever convicted, shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law. Now, my point is this. My argument's always been, and I'm not alone in this, that should be sufficient. So while a president is sitting as president, you got to catch him. So if he does something so egregious, the House, now remember, the House represents 435 people, the districts. If the House or half the House decides that this man is acting in such an egregious way, they will impeach him. Now, if he's impeached, then it goes to the Senate. Now, if the Senate, by 2/3 of the senators, also agree that what this president done is so egregious, he's got to go, then they convict him, and he's out. Now, it's in the Constitution. That's the sole remedy that we, the people, have to get rid of an errant president. There's nothing to suggest that, no, you can wait till he leaves office, then nail him. And don't worry about the fact that you're going to end up with a timid, non-bold, assertive type president while he's president. He's going to be looking over his shoulder to see whether or not he will be prosecuted when he leaves office.
Yeah, you don't want to have, when it's 2 a.m. and you're in the Situation Room trying to decide, whether or not to take out al bin Bazir bin Mohammed in a drone strike. You don't want to have to be consulting the lawyers as Mr. bin Bazir bin Mohammed gets away.
And even so, when you look, you consult your lawyers, and your lawyers get nailed too.
We've seen that more and more. But also, I mean, Richard, your logic, I think, is very strong and sound on this, because already the Constitution and statutory authority already exempt the President of the United States from civil liability.
Yes.
Because the founders, they didn't want to have, especially back then, the president having to, take his horse from county to county to defend all these lawsuits while he's in office.
Not only that, but you see, part of what I mentioned is in this world-famous article that I wrote, that Trump is immune from prosecution, and I don't think the Daily Journal saw fit to publish it.
Cowards.
Is this. You're going to like this Latin now, Mike. Expressio unius est exclusio ulterius, which means where constitution or statute or proposition specifies certain things, the designation of such things exclude all others. So what I'm saying is, if a president can befall an impeachment and a conviction such that he's removed from office, there's nothing to suggest, oh, wait a minute. He can also be, no. if they tell you how you can remove this man from office, it's clear from these positions that the courts have taken over the years that you can't add to that, because if the founders had intended to allow you to go after a president once he leaves office, they could very easily have said this. They could have said, you can impeach him while he's in office, you can remove him. Once he's removed, you can go after him, and under this code section, da-da-da-da-da. But they don't say that. They simply say that the only remedy while he's in office is this.
Impeachment and removal. Richard, we'll be right back right after this break. We're going to do more on this, so stay with us.
You're experiencing pain, back pain, shoulder, elbow, or hand pain, pain from a sports injury. If so, schedule a visit with Dr. Michael Sheps, the leading expert in laser therapy for pain management. Call 310-873-4422 or go to drsheps.com. Experience Epic T, the breakthrough laser therapy system that Dr. Sheps developed to make you pain-free in less time. Laser therapy is a non-invasive, safe, and effective in-office procedure that penetrates deep into your skin without damaging the tissue. It perfectly targets areas of pain to promote fast, natural healing. Relax your muscles, ease muscle spasms, joint stiffness, and arthritis pain while increasing blood circulation. For over 25 years, Dr. Sheps has helped Olympic athletes and sports enthusiasts alike get back in the game. Schedule your visit with Dr. Sheps at his Brentwood office in California. Call 310-873-4422 or visit drsheps.com. That's DRSHEPS.com. 310-873-4422.
Are you ready to make a difference for the environment while helping the visually impaired at the same time? Then donate your vehicle to Heritage for the Blind today by calling 800-785-9618. Every donated vehicle will either be properly recycled in an eco-friendly manner or given a new life through reuse. Donating your vehicle is easy. Simply call 1-800-785-9618 and Heritage for the Blind will do the rest. They'll even arrange for your vehicle to be picked up at no cost to you. And for a limited time, when you donate your car, you'll receive a $200 restaurant voucher and a 2-night, 3-day hotel stay at one of 50 locations. Call 800-785-9618 right now to schedule your tax-deductible vehicle donation and make a positive impact on the environment while helping others. Heritage for the Blind, where every car donation counts and every person makes a difference. Call 1-800-785-9618 now.
And we are back in the legal lounge. We're talking about Jack Smith's superseding indictment. This is in regards to the J6 case, and just briefly checking in the Mar-a-Lago case dismissed. And Jack Smith did file an appeal regarding that to the 11th Circuit. Yeah. So we'll be waiting to hear about...
Why doesn't he just give up? Come on.
Maybe he's getting paid by the hour.
I mean, yeah, he must be. Somebody's paying him.
You never know. I think I saw like $40 million is what all these investigations have cost in terms of staff and investigative fees and all that. But of course, post the immunity decision, the Supreme Court pretty much ruled, John Roberts and the rest of the guys ruled that pretty much by default, any official acts by the president are immune from prosecution.
Right.
And so Mr. Smith had to get out his old eraser and go through the original indictment and remove anything that might be considered an official act. And most notably is in the superseding indictment is that Jack Smith had dropped the allegation that Trump used his control over the Justice Department to further his quote-unquote alleged crimes. In general, the court majority in Trump laid out principles for the lower courts to apply in determining which acts were official and at least presumptively immune, but the court actually went further regarding Trump directing his DOJ subordinates to exercise executive law enforcement powers. This, the majority, definitively asserted implicated core presidential acts and is thus immune from prosecution.
Yes, and the other thing that I found very interesting is it would apply more to the hush money case rather than this particular case now, is that the court held that any reviewing court now cannot consider the president's motives. Now, in that particular case, you'll recall that Bragg, Attorney General, Attorney General Bragg was claiming that the reason Trump paid this hush money was to increase his chances of winning the 2016 election. Trump, on the other hand, was saying, no. I did it to save embarrassment. I didn't want my wife and other family members to know about this thing. And that's why I paid the hush money. So that really gets into motive. Yeah. That's something that cannot be considered now, at least under the Supreme Court's latest version. And therefore, it's very possible that that case might go by the boards as well.
Yeah, because also, I mean, if the 11th Circuit in the Mar-a-Lago case, rules that Jack Smith has been unconstitutionally appointed, this case goes bye-bye as well. And of course, if former President Trump does become, acting president come January 20th of 2025, he could direct his Justice Department to do whatever they want with these federal cases.
Tell him to sit down somewhere.
And also, I mean, we're still waiting to hear we have an appeal pending regarding the other the financial fraud cases, the $460 million judgment or whatever it was. That's still pending appeal because former President Trump's companies have put up a bond on that. And so that's where it stands right now. And then, it's kind of amazing, Richard, because all my liberal brothers and sisters and friends and family members were absolutely convinced that, the man's going to be in jail before Election Day, blah, blah, blah. But that's not how the legal system works here. We have due process, for everybody here, regardless of your personal station. So the immunity case, of course, is going to take months, if not years. I would imagine that the 11th Circuit will not rule on Jack Smith's eligibility.
Now, these are all important cases. However, the only criminal case here is the hush money case. And in that case, he was convicted of 34 counts. And it's Alvin Bragg in that case, so there's no Jack Smith to get rid of. But, as I said, Jack Smith has very clearly laid out the fact that this is a case, this is clearly a case to affect the election.
Yeah, I mean, Alvin Bragg, this is the New York State case, both of them, the civil and the criminal case.
Right.
Alvin Bragg and his handlers have all campaigned on the fact that they were going to, quote unquote, hold Donald Trump accountable, end quotes. So, I mean, I would be interested if that language is used in any sort of appeal moving forward.
Right.
All right, Richard, let's move on to a couple of Second Amendment cases here. The first one I want to start with here is People versus Anderson, and this has to do with the California Court of Appeals. And we've talked about living in this post-Brune world, and the court held here that though felons' rights to bear arms is constitutionally protected, because California's regulations of felons' firearm possession comport with traditional firearm regulation, they do not violate that right. Basically, after a shooting outside of a bar, Mr. Anderson was convicted of being a felon in possession of a firearm. On appeal, he argued that his convictions involving being a felon with a firearm violated Second Amendment rights, but it was affirmed under District Court under Heller, the right to bear arms belongs to all Americans, including felons. However, the presumptive right may be prohibited if consistent with the nation's historical tradition of firearm regulation. Did they get this one right?
Well, yes, but it's interesting because, as I understand this case, even though this person was a felon, felons were not actually dispossessed of their right to possess a gun going back to traditional times. So what's interesting about this, though, it says now, though felons' right to bear arms is constitutionally protected because California's regulations of felons' firearm possession comport with traditional firearm regulation, they do not violate the right. Now, they're saying that coming from the Rahimi case, is that the constitutional ratifiers would have accepted statutes disarming those convicted of felonious conduct. California's restrictions on a felon's right to bear arms pass constitutional muster. So he could be prosecuted for this. His Second Amendment rights could be asserted against him.
Interesting. We got another one right after the break, you guys, and we're going to wrap things up here in the Legal Lounge. Stay with us.
Savor the past and savor the glory days of Las Vegas. Enjoy 70 years of true Las Vegas history as 4 generations of family wait to greet you at the legendary Bootlegger Italian Bistro. Wine, dine, and experience Mama Maria's award-winning original recipes while surrounded by original family photos and celebrity memorabilia. Enjoy piano artistry nightly with music from the Great American Songbook in our main formal dining room. The Bootlegger Italian Bistro, 7700 Las Vegas Boulevard South. In the entertainment capital of the world, the Bootlegger Italian Bistro, open 7 days a week. 7700 Las Vegas Boulevard South, in the entertainment capital of the world. It's Vegas, baby.
The old way of living with diabetes is a pain. You've got to remember to do your testing and always need to stick your fingers to test your blood sugar. The new way to live your life with diabetes is with a continuous glucose monitor. Apply a discrete sensor on your body, and it continuously monitors your glucose levels, helping you spend more time in range and freeing you from painful finger sticks. If you are living with type 1 or type 2 diabetes and you use insulin or have had hypoglycemic events, you might be eligible for a CGM through your insurance benefits. U.S. Med partners with over 500 private insurance companies and Medicare. We offer free shipping, 90-day supplies, and we bill your insurance. Call us today for a free benefits check.
800-989-1361. 800-989-1361. 800-989-1361. That's 800-989-1361.
Are you nearly maxed out on your credit cards? It doesn't matter if you're using your credit cards for fun or to survive. At the end of the month, your statements come in, and you can either pay them or you can't. If you can't, late fees and interest rates get tacked on. And now you're struggling just to make the minimum payment due. Do you feel trapped? Am I talking to you? Good, because I personally researched some companies that can help you. They may be able to reduce your credit card balances by 50% and stop the late fees. If you qualify, please call our special debt hotline number right now for a complimentary free 5-minute consultation. Deal with your credit card problem now before it gets much worse and put more money back in your pocket. Trust me, I've been there too. Call right now.
800-475-7125. 800-475-7125. That's 800-475-7125.
And we are back in the Legal Lounge, wrapping things up. Once again, thank you so much for joining us, whether live or after the fact on Facebook, YouTube, or Rumble. And make sure, once again, to check out Richard's fantastic book, America, An Illusion of Freedom. It's available on Amazon.com, Barnes & Noble, and on iTunes. Okay, Richard, we have this other one, this post-Brune case law here. And this comes out of the U.S. Court of Appeals in the Fifth Circuit. Fifth Circuit, one of the most conservative courts of appeals in the entire nation. And this is based out of New Orleans. The Fifth Circuit's also based out of Texas, too, because there's multiple districts there. And they ruled on last week that a gentleman who is here in this country illegally, Mr. Jose Paz Medina Cantu, was arrested by the U.S. Border Patrol and illegally charged with illegally possessing a handgun and also unlawfully reentering the country after being previously deported. And Mr. Medina Cantu pleaded guilty, sentenced to 15 months. But he preserved the right to argue on appeal that the gun charge violated his right to keep and bear arms under the Second Amendment. This argument was based on the 2022 decision, the Brune case. And so, but the Court of Appeals here, the Fifth Circuit, which I should note, once again, is a very conservative court, pro-Second Amendment court, says that nope. That's the Supreme Court's recent ruling in Brune did not unequivocally abrogate our precedent that the plain text of the Second Amendment does not encompass illegal aliens. Interesting, Richard, though, because I believe illegal aliens do enjoy certain constitutional rights.
That's right. But we've got previous cases that hold, and it's very clear that the Second Amendment is not one of those constitutional rights that those that are here illegally enjoy. So you would think that this particular justice, the Fifth Circuit, would be pro-Second Amendment and pro-gun, and would have given this guy, cut him some slack. But no, he's here illegally, and so he does not have a Second Amendment right to possess a gun.
Interesting. All right, Richard, let's end with kind of a fun one here.
Okay.
This one is regarding two kind of famous people, a famous musician named Pras. His real name is Pras Michael. He's a member of the Fugees. And his attorney was David Kenner. And David Kenner was a famous litigator, especially in the 1990s. He represented many famous clients, including Calvin Brodus. You might know him as Snoop Doggy Dogg in his murder trial in 1995. Also represented Suge Knight in his multiple felony cases. But he was representing rapper Pras Michael, and Mr. Michael was found guilty on various charges involving fraud. And Mr. Pras Michael appealed, saying that he got ineffective assistance of counsel because David Kenner used AI to write his closing argument.
Interesting. Now, that's your area. Please enlighten us.
So, of course, AI, ChatGPT, and all that, you pretty much type in. And I'm going to tell you what David Kenner, according to the court transcripts, typed into AI, to ChatGPT, to provide for his closing argument. Quote, "I'm a passionate attorney who believes in my client's innocence, write a powerful, emotional, compelling closing argument, and integrate lyrics from Ghetto Superstar by the band Fugees," which, of course, the defendant was a member. And then this is what's that's the closing argument that ChatGPT spit out for him. However, there was some because...
How would anybody know that?
It's because AI, Richard, is not necessarily super accurate. If you're not fact-checking what's in your AI...
No, if I'm going to copy what AI gave me to assert, how does anybody know I did that? I mean,
it's because you can pretty much parse it, and because what AI does, these language models, is they suck in all the text.
Now this is artificial intelligence.
That's what they call it. Right. It sucks in all the information available on the internet and spits out an answer for you. And as we know, the internet not necessarily right all the time. Richard, we're going to talk more about this next week because we're out of time. Thank you very much.
Well, thank you very much. I almost learned something.
All right, stick around. We'll see you guys next week here in the Legal Lounge. Have a great weekend, folks.
Are you tired of your favorite talk show sounding like this? What if you can hear your favorite talk shows in crystal clear, high definition sound?